All right, you're watching Live Now. I'm Austin Westfall. Let's continue discussing the trial of the man accused of assassinating Turning Point USA founder Charlie Kirk. He made his first in-person court appearance Thursday, as Molly Roy was reporting to us just before the break. This is the first time in nearly 3 months after he was taken into custody that we've seen him in a courtroom. Robinson is charged with aggravated murder and felony use of a firearm. He's also charged with obstruction of justice, witness tampering, and commission of a violent offense in the presence of a child. Randy Zelin is standing by. He's a criminal defense attorney and former prosecutor. So, Randy, Robinson has not yet entered a plea to these charges. It seems, though, and you might have seen this in the media, it did seem that he smiled in court today, and that did make some headlines. How might his behavior factor into strategies by prosecutors or defense attorneys as this case moves forward?
Well, I don't think that it's necessarily a matter of strategy. Certainly, if you are defense counsel and you are aware of the fact that as Utah permits, there will be one videographer, one still photographer, it is important that your client remain stone-faced, that your client remain as serious and as serious as the gravity of this moment calls for. Smiling in a case like this, probably not a good look. Is a potential juror going to recall that? I don't know. So I wouldn't say strategy as much as I would remind my client, as I would remind myself and anybody else on the defense team, that every single thing you do is going to be watched. And it takes 1 second to say or look the wrong way or say the wrong thing, and that egg cannot be unscrambled.
So as we continue to look at some of these images of him in court today, these are some of the stills that were captured by the Salt Lake Tribune, one of the local papers out there. Much of this case, Randy, has unfolded behind closed doors before today. That has led to many people, including Charlie Kirk's widow, Erica Kirk, to call for more transparency. Can you explain the legal standard that a judge applies when balancing the defendant's right to a fair trial with the public's interest in transparency?
Well, here's how we start. We start from the perspective of our judicial system has been created with the fundamental notion that the citizens of this country need and have earned the right to transparency in their justice system. We do not do things like a star chamber. We do not do things the way things were done before we became a country in Great Britain. In our system of justice, you can walk into any courtroom anywhere in the United States, have a seat, and watch. And of course, with the advent of 24/7 news cycles and technology, cameras are permitted, and states in particular are allowed wide berth to determine whether or not cameras are permitted in the courtroom. In federal court, cameras are not permitted in the courtroom, but certainly members of the press are free to go into the courtroom, sit there, make notes, and then report on what the journalist has seen and what the journalist has heard. So on the one hand, we want transparency so our citizens can be confident that our system is working as it should and that it's done open and notoriously. That's how we instill confidence. By the same token, we want to ensure that a defendant who is presumed innocent, and that is the critical takeaway, a defendant is presumed innocent, and accordingly, we do not want a potential juror prejudiced by something that may take place in the courtroom and even outside of the courtroom that might affect that juror's ability to be fair and impartial, because the juror may say something, or may hear something or may see something that never makes it into evidence at the trial. No evidence has been received. So we need to balance transparency with not prejudicing the right of a defendant to a fair trial by a jury of his peers, by jurors who will judge him and the evidence fairly and impartially, and who will presume him innocent. So a judge will look for signs of prejudice. In Utah, the judge can say, nope, this isn't working. The defendant is being prejudiced, actual prejudice, no more cameras.
So at this point, what strategic options does Robinson's team have? He hasn't officially entered a plea yet, so what are his choices? What are the team's choices moving forward?
I would think that the team would fight like hell and really fight like hell to keep the cameras out of the courtroom, to convince the judge that Mr. Robinson will not be able to get a fair trial, that jurors are watching, they are hearing, they are seeing. It is putting them in a position to hear and see not evidence, because nothing is in evidence yet, and that all of this outside stuff is going to get into their brains. And there's no way, it's not like this is Men in Black where we can flash the light and their memory has been wiped out. And that if I am the defense, I am going to argue that given the magnitude of this case, the magnitude of the stakes of this case, the possibility of the death penalty, we must err on the side of caution, and cameras in the courtroom are going to unduly prejudice Mr. Robinson's right to a fair trial.
With prosecutors seeking the death penalty in this case, Randy, what crucial legal and procedural steps are going to come next? What do we need to watch for in terms of pretrial motions, mental health evaluations before things can proceed to a trial?
It's difficult to say, since we really don't know very much about the defense strategy. We don't know if the defense is planning on interposing some kind of a mental disease or defect plea. In other words, that Mr. Robinson was unable to appreciate the nature and the circumstances of what he was doing. He was unable to appreciate that he was committing a crime. He was unable to appreciate right from wrong. That would be your mental disease or defect defense. That would be your insanity defense. What other defenses Mr. Robinson might have? Ostensibly, could he say, it wasn't me? And he has no burden of proof, but to go into a trial and essentially take the position that the prosecution has the wrong person. Is his defense going to be that he was not shooting at Charlie Kirk? We simply don't know. And again, the defense has no burden of proof. The burden of proof rests with the prosecution. So I think right now the defense is going to be working overtime, not only to keep cameras out of the courtroom, but to get as much evidence, as much facts, everything that they can get from the prosecution, either through discovery or through pretrial hearings, pretrial motions. Keep in mind that the purpose of pretrial hearings and pretrial motions as a defense strategy is not merely to try to win them. It isn't merely to try to keep evidence out of the case. It's not merely a matter of keeping any confession out of the case. It is not merely a matter of moving to dismiss the indictment for lack of sufficient evidence or some other defect. Yeah, it would be great if you could do that. But there's another reason, and that reason is you get discovery. You force the prosecution to cough up their proof. So the defense is going to create as much as it can by way of motions and hearings to get as much information as the defense can get to determine what the best course is. Is this a road to a plea deal? Is this a road to a trial? And if it's the road to a trial, can I generate inconsistencies that I can use to bolster my defense and give my client a chance at not ending up in front of a firing squad?
Randy Zelin is a criminal defense attorney and former prosecutor. Thanks as always.